because the body, my opinion in this regard is inconsequential. What is important is what the Constitutional Court has stated. But not only that, what had actually happened before that, President Lungu's people, 3 surrogates, went before, I think this was 2017 or 2018, they went to court and posed the question whether President Lungu, having taken part in the election of 2015 and 2016, was eligible to stand in 2021. The Constitutional Court said, yes, he is. In that case, I argue to say this question is premature. We can only resolve it once he has filed his nomination. Okay. When I went to file the papers, now to challenge, this is now 2021, the court said, no, sorry, we have already ruled in the case of Dan Pule that he is eligible to stand. We are sticking to that. Okay, and they went on to amplify their reasoning to explain why President Lungu was eligible. So it's not. I'm just trying to explain what transpired. I took a position, and that position the court disagreed with me because that's the most civil way of resolving disputes. Okay, so that is the position of the court, and that is the law as we speak right now, based on the interpretation of the Constitution by the Constitutional Court. President Lungu qualifies to stand in the next election. Okay, that is the position. That's what the court said. Okay, but again, we didn't just start saying, oh, there is a lacuna here or there is this. Nobody talked about a lacuna. What did the people do? They went to court, and the court guided. Okay. And that is what I have a problem with. If people believe there is a problem, go to court. But it is no reason for you to initiate an amendment to the Constitution.
Okay. Hello, good morning.
Good morning, Ochi.
Morning, sir.
And good morning, State Council Sangwa.
Good morning.
My name is Isaac Mwanza. I am one of those that petitioned the court on the issue of Article 52(6) of the Constitution. And the judgment of the court in the Mwanza and Sinkamba case versus the Electoral Commission of Zambia. It's a 2022 case. The full judgment was delivered last year in December. The court had to pronounce itself on Article 52(6). And our argument was that if the election, for instance, if it was about the Kabushi and Kwacha general by-election, and our argument was simple that if ECZ was not going to hold the election within the 90-day period provided by the Constitution, and they hold it outside, that would be unconstitutional. And the court, when interpreting this provision of the Constitution, they stated that if that situation happened, that the 90-day period elapses because of the cancellation that has happened in an election, it will still remain constitutional. Now, this is the problem, because the court will still interpret the same way when you talk about the general election, one of the election in a presidential election, that could be held in 2026 or 2031 or whenever. If a presidential candidate resigns, the other elections would go ahead. But if the Red would need to have time to prepare the ballots, they would need to do the tender process and all that. And that is why I think the hypothetical question which was asked to you to say, can it take a year to hold an election still stands? Because there are all these processes that you have to look at in terms of the printing and ensuring that there is no contention. Now, that is the problem. It is the question of amending the Constitution a solution. There I somehow agree with you. And if you look at my analysis on this matter, I have said that we cannot be amending the Constitution all the time we see a problem in it. The problems with the Constitution. And they needed to be dealt with by a court because some of the things we do not foresee them. So I prefer the route of going to the Constitutional Court of amendment. But if the people say it is okay, we can amend the Constitution, would I say no? I wouldn't say no. Why we are at this stage, State Council Sangwa, is because of what happened in 2016. The provision in Article 52(6) was manipulated in Parliament in 2016. I'll read you what the provision was. It was Article 79 in the final draft Constitution. And I'll show you how it was manipulated in 2016 when the amendments were being done. If you look at the final draft Constitution, this article appeared on Article 79. Article 79 was very, very clear. It didn't have provisions that have to talk about determining fresh nominations and all that. It was explicitly stated. I hope you're going to allow me, Luchi, to read this provision.
Very briefly, if you can.
Okay, yeah. So, Article 79 of the final draft Constitution states that, I beg your pardon, it states that, yes, I'm here now. Article 79(6) of the final draft, it says that when a candidate dies, resigns, or becomes disqualified in accordance with Article 98, 129, 190, or a court disqualifies the candidate for corruption or malpractices after the close of nomination and before the election date, the Electoral Commission shall cancel the election, and elections shall be held within 90 days of the cancellation, within 30 days of the cancellation. You see how simple it was. It didn't talk about the fresh nominations and the elections being held 30 days from the date of fresh nominations. No. So this was manipulated. But also, I also wanted to bring to your attention that we had two nominations that were proposed under the Constitution. One was under Article 79, another one was under Article 128. Under Article 128, it was a party list system. What cap did the court put, the framers of the Constitution put, to ensure that the resignations do not happen a day before an election? They had put a cap that if a party removed the person from the party list system and wanted to replace them, they could do that at any time, but not within the 30 days to an election. That was a provision that was also, if you read the report, they said that provision was going to apply to these nominations under Article 79. So we have a good situation where within 30 days before an election day, if you resign or you die, as long as it's 30 days to an election. But now we have a challenge, and we need to deal with this challenge. I think the best way is to get to the court.
Mr. Monza,
thank you.
Thank you very much. Thanks a lot for coming through. Do you want to respond?
Yeah. Just a few points.
Yeah.
I mean, the Constitution is not a perfect document. It is drafted by human beings, and the Constitutional Code. Now, if there is a general consensus in the country, at the end of the day, the ultimate authority is vested in the people. If there is a consensus in the country to say we need to amend this constitution, then that should be so. Then that will be a reflection of the will of the people. It is for the people to demand the amendment of the constitution, but not the president. Okay, that is how our system is supposed to work. But which again. We still have to take the constitution as it is, in the sense that in the original draft, in the original bill that went to the National Assembly, it provided for proportional representation, and that is why there was talk about a party list. Okay, that was removed, and that decision to remove was between PF and UPND. That was the decision they made. Now, and that is why we have ended up where we are now. We have to accept the constitution the way it is now. But if the people say, well, this is what we want and so forth, and it is verifiable that that is the case, yes, it can be amended. But I'm strongly opposed to amending constitutions anyhow. Here is my reason. You see, we have to be careful about these things. We have a very good legacy in that power has always been transferred smoothly. In 1991, Kaunda lost the election, and he graciously agreed, conceded defeat, and power transferred peacefully to President Chiluba. In 2000, President Chiluba lost the election. First of all, he tried to bring in the third term, and people rose in defense of the constitution, and he ended up conceding. Okay. In 2011, President Banda conceded defeat and passed over power peacefully. President Lungu lost power in 2021, and he graciously surrendered power. Now, that is something that we have to celebrate, but it's not something that we should take for granted. When we allow constitutions to be amended, one of the things we must remember is that in the 1960s, 70s, and 80s, dictators came to power through violent means. But today, dictators come to power through the ballot. Once they're in power, they start tinkering with the constitution to the point whereby it becomes difficult to remove them from power. That is something that we must constantly watch out for. Okay? And that is why I am saying this document is a bipartisan product between PF and UPND. Now, if there are all these, whatever they are calling gaps, my point is that why didn't they see them when they were passing the bill in 2016? Okay? They had the opportunity to do that. So we have to embrace the Constitution and live with it. Okay? Until and unless we have evidence that the provisions of the Constitution have failed, only then will we have cause to amend the Constitution. But that is such a decision cannot be based on supposition or all these hypotheticals. It's a very dangerous route to take, and that is why I'm strongly opposed to such an amendment. But also, I keep saying, you have a problem. Pass an act of parliament. It can address that.
Okay.
Nothing stops, for example, to pass an act of parliament to correct this, to say in the exercise of its authority under Article 52 6, the Electoral Commission shall set a date, okay, within 7 days of the cancellation. Nothing stopped. You don't need to amend the Constitution. You can pass an act of parliament, and that act of parliament will be consistent with the Constitution. But please don't touch the Constitution.
Okay. Hello, good morning.
Good morning, Madam.
Good morning, sir. What's your name?
This is Mr. Lupez, and I'm calling from Shillawong.
Okay, go ahead, Mr. Lupez.
State Council, good morning.
Morning, sir.
Yes, I think my contribution is very, 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 very small. And in as much as I've been trying to get you from the start of the program up to this time, I know that where the mistake is, or where you are trying to disagree with the presidential consent, is just by the term lacuna. But in your entire explanation, you have agreed to say we cannot go this way instead of just giving powers to the ECZ to try and change. And as a lawyer, that is why you need to sensitize a lot of people so that people should be able to know. Then again, don't distance yourself from government. Because in as much as you can have a good point, you end up on just making noise. But the bottom line is you have agreed, and that is what is important. Because the president's concern is very genuine, and it's also genuine. Because in an event that we're having 30 presidential candidates, and everyone is withdrawing at an 11th hour, for example, the 18 hours will be the end of campaign. Then somebody withdraws at 12 hours, and that letter of resignation or that letter of withdrawal reaches the ECZ. Automatically, the ECZ will change the date of elections. Meaning, if all these 29 are going in that particular same situation, we are going to see a situation where the presidential stay in the office will prolong, which we cannot say this is right, this is wrong, and it will also continue wasting government resources. Because every time when the nomination is conducted, there are resources that will be spent. And this is something that we should also fight as Zambians, so that we can try to remove that mistake or that concern, and try to put it in a situation where if somebody resigns or withdraws, they should take place at the date that has been set by the ECZ. Thank you so much.
Thank you very much, Mr. Lucas. Do you want to respond to Mr. Lucas, or can I add another call? Let me add another one.
Yeah.
Before you go there. Hello, okay, lost you on that line. 0978-895-895. Hello, good morning.
Hello, Lucho.
Yes, good morning, sir.
This is me. I'm calling from Deke Township here in Dora, Lucho. Once again, I just want to thank you for picking my call. Council Sangwa, how are you?
I am well, sir.
Thank you so much. Council Sangwa, if you lawyers were doctors, believe you me, most of us as patients could have died. I am saying this because you lawyers yourselves, you are actually failing to understand the Constitution and interpret it accordingly. For example, you are on record of having said President Lungu does not qualify to stand.
I think, Mr. Meji, sorry, before you continue, I think this point was explained by Mr. Sangwa earlier on.
Okay, allow me to say this. Former President Edgar Lungu is on record of having instructed his cabinet to remain in office despite dissolving parliament. When his election was petitioned, Lungu was supposed to hand over power to the speaker. He couldn't do that, and yet he is a top-notch lawyer. But having said that, Lucho, the Constitution belongs to everyone, including me. And my demand right now is that Article 52, Clause 6 must go. And it must go forthwith without wasting time. You cannot allow that article to stay there. In an event one pulls out, in an event the other one is convicted, who have prolonged election, it has to go, and it must go now. Thank you.
Mr. Meji, thank you very much. All right, essentially saying same as a few others. Let me take another call. Hello, good morning. Good morning. Hello. Okay, I think he's listening to Mr. Meji on the other end. Hello, good morning. Hello.
How are you?
I'm all right, thank you, sir. What's your name?
Fine, thank you. My name is Soko.
Okay, go ahead.
And I'm calling you from Chingola.
Go ahead.
Thank you very much. Luchi, first and foremost, I want to say that I was part and parcel of the people that were debating the Constitution, the draft Constitution, at district level here in Chingola, and at provincial level on the Copper Belt. And one thing that I can vividly say here, under Article 52, dies, resigns, or withdraws from the rest, the Electoral Commission of Zambia, or should I simply say, the nomination shall be demanded to be filed in, and an election shall be held within 30 days. It doesn't say beyond. It says within 30 days. So the Constitution is quite clear and expressly stating the fact that where there is this challenge, which it foresaw,
could happen. Therefore, the election can be held within 30 days. So there is no debate that we can even come up with. And the only way we can, if at all we need a clear guidance and interpretation of this provision, is to go to the Constitutional Court, because the Constitution has already provided and pronounced itself in that regard. Thank you.
Mr. Soko, thank you very much. Thanks a lot. Do you want to respond?
Yeah, there's a point that he has raised, which is very important. Okay, now he mentioned two things that are important in the sense that this draft constitution, first of all, the way it happened was, when President Sata put together the technical committee put together a first draft constitution. Now, it is this draft constitution that was debated in all the districts in the country. Okay? And in fact, of all the constitutions we have had, texts that we have had, this was the most highly debated constitutional text. It just confirmed that it took part in a district discussion at the district level, and also discussion at the provincial level. Then there was a subsequent discussion at the national level. Okay, so since the constitution has gone through all these processes, you can't just wake up one morning and say there is a lacuna here, let's change it. Okay. It was not. You are saying all these people that we are looking at these things at district level, national, provincial level, national level, including the various committees of experts that assisted the technical committee, didn't know what they were doing. That's essentially what we're talking about. And yet, this was a document that was widely debated. Okay, and that is the premise on which I say, listen, let's hold on to it. Don't change it. Let's see how it acquits itself.
Okay, let me ask you this.
Yes.
And let me also just announce. So I'm playing devil's advocate this morning.
Yes.
So I want to play devil's advocate again for this particular question. So let's imagine, how would you change this particular article? Okay, fine, it may not be through an amendment. What other avenue is there that you can use to clean it up? Let me use the phrase clean it up instead of...
Okay, you can go to court. No, you can go to court. And the court can guide, either narrowly interpreted, or there are various principles on interpretation of the Constitution. Okay, the court can guide. But it cannot be our responsibilities to be able to attack it, to say we don't like this and so forth. No, if you have a problem and if you have certain fears, that is why the Constitutional Court exists. There are many other provisions that we may have issues with. Now, tomorrow it will be another provision. We also go we amend it again. How many amendments are we going to have? Okay, but we have to allow this Constitution to breathe. Okay, you have your view, I have my view. Okay, now it doesn't mean then whose view is going to prevail here. Now, if I feel strongly, I'll go to court, and the court can guide. This country has never failed to have a by-election or an election on account of Article 56, 52, 6.
The reason I asked the question is because, and I just want to say thank you to the person who sent this text. There's somebody who made reference to the American case Roe versus Wade,
yes,
which was recently
overturned.
Overturned.
Yes.
So obviously they had a specific clause in their own constitution. Roe versus Wade changes that. Now, in our case, if we use our example, we have a particular case, and I don't want to delve too much detail into it, but there's a case that we have that is currently in court, asking the Constitutional Court to make a determination on something that we can argue or not whether they've already decided.
Yes.
So I don't know if you can see where I'm going with this, to say, fine, I can go to court tomorrow and I can ask the court and say, look, I want to challenge Article 52.6. The court will pronounce itself. She will come 2 months later and say, hey, listen, I want you to make a further determination. Then again, another 6 months, you come down and say, actually, I want you to make... Do we not see ourselves, because again, precedence has shown us that people seem to be going to the court to ask them the same question in the hope that they'll make a different determination? Do we not see ourselves in a situation where they might end up making a determination on this particular question that varies differently?
No. So far, there is no evidence of that. And like I said, in the case of Lungu, not once, but 3 times.
Well,
okay.
There'll be a fourth.
Yeah?
There'll be a fourth.
Yeah, we don't know what the fourth will look like. But the point, let's talk about what we know. So there is the case that was done. I took to court, okay, where there's the Constitutional Court, okay, but they have to be responsible. There is need for consistency. Now, if you have to depart from a certain decision, okay, there has to be compelling reasons. For example, with the American situation you're talking about, there's a 50-year gap. And in 50 years, obviously, people's perception of views have changed on the subject. Because the mood of the country does not remain the same. And not only that, the court that decided the decision 50 years ago is not the same court that decided the case recently. Okay, so there is that gap, and society is not static. But the point is that we need to have trust in these institutions that they'll be able to guide us. But the answer is not amendment of the Constitution. That is where I have a problem with. Let's go to court. After all, those judges need to end their pay, although it's not much. But the point is that they have nothing else to do but just to interpret the Constitution. They'll guide us.
Okay. Here's let me go to the phone line. Hello. Good morning. Hello. Good morning. Hello. Good morning. Hello. Hello. Good morning. Okay, lost you on that line. Let's try this other line. 22641 0978895895. Hello.
Hello.
Morning.
Good morning.
Morning, sir. You're live on radio. What's your name?
My name's Kabamba Edward, calling you from Kitwe.
Yes, Mr. Edward.
Yes, sir. I just want to contribute on this discussion which is featured Mr. John Sangwa. Mr. John Sangwa, you're fine.
Yes, I am, sir.
Yes, sir. I just want to say that no constitution, there is no perfection in every constitution. Because from the inception, the American Constitution, which is, if I can say, it's the oldest constitution in the world, it has been subjected to the amendments for about 27 times. But what I'm trying to emphasize on is that we shouldn't be amending the Constitution. When amending the Constitution, we have to be genuine, not just amending the Constitution. Because there is a tendency in this country whereby the people, the framers of the Constitution, they amend the Constitution to favor themselves. But the Constitution is for everyone. So when amending the Constitution, it has to be genuinely amended. This is what we need, not just to favor a certain political party or to favor one interest. We have to amend it genuinely. Thank you very much.
Okay. Yeah. Do you want to respond?
Yeah, I mean, that is the premise of that. I mean, one of the reasons, for instance, why there was opposition to Bill 10 and so forth was clearly an attempt to use the Constitution as a political tool. And you see, this is not the first time. And that's why, I mean, I hope Zambians are listening. We've been on this road before, okay? In 1996, there was an amendment to the Constitution simply to bar Dr. Kaunda. Okay, it happened to disqualify him, and that is not the purpose of the Constitution. We must guard against situations whereby an incumbent president can use the Constitution to his advantage. Okay, those are the dangers, and President Lungu tried it with his Bill 10. Okay, for example, there was this crazy proposal which was designed to modify the 50+1, which says, which I think they wanted to say, when no candidate gains more than 50%. What happens is that you can actually go in an alliance with the next person who gets with whoever, so that you go above 50%. Okay. Now, this was clearly it was a very weird provision, but I think these people were drafting it with themselves in mind. Okay, that is not the purpose of the Constitution, and that is why this Constitution, because it is a bipartisan product, that is why it has to be defended. Now, here's an interesting point. When PF was in power, UPND saw everything good about the Constitution, including Article 52. Okay, UPND, it was okay. PF saw nothing good in it, but now the tables have changed. The language has changed, but Article 52.6 hasn't changed. Okay, that tells you that there is value in that particular provision, and we have to protect it at all cost. Okay, just like we resisted its repeal under PF, we also have an obligation to make sure that it is not repealed under this government. Okay, now I agree. When you amend the Constitution, it is us, the people, to demand its amendment. But even when we demand its amendment, there has to be a basis on which we make such a demand. It cannot be an emotional decision or decision that is based on assumptions and suppositions.
Okay, let me play you a voice now from somebody.
Council, in disagreeing with what the president said, and I mean on the Constitution, and the remarks also from ECZ chairperson Madam Zaromis, who I worked with. She was our spokesperson at the NCC. I'm sure you remember the NCC State Council. Yes, so in disagreeing with these two, I think I want you to shed more light on Article 2 in Part 1. Article 2A-B, and also married with Article 3. Just educate us on that, shed more light so that Zambians know that they've got right to defend this Constitution. State Council, have a good day. Thank you.
Thank you. Now, before I do that, there is something very fundamental which we're all missing in this issue. First of all, there is this debate about the involvement of ECZ in this debate. That in itself is a violation of the Constitution. Okay? Two, and that is why I've disagreed with the president, also the pronouncements that he made. Now, the provision of the Constitution is very clear on the. I think there is a piece which is circulating where somebody is criticizing the decision of Mrs. Alumis to initiate electoral reform.
I've got it here. I can read it for you. Just give me a second. I've got it here. I can read it for you. She's calling it Just hold on. My eyesight is quite bad. ERTC. ERTC would be. Actually, I don't have it here. Oh, Electoral Reform Technical Committee.
Yes. Yeah. Now, I think somebody has already done a piece to illustrate that the Commission has no authority to do that, which is correct. Because whenever you initiate something like that, you have to point to a provision of the law that empowers you to do that. Okay? And if you look at it, there is absolutely no provision in the Constitution or in the Act that empowers the Commission to do what they are doing. And they have even extended further to begin to talk about the constitutional provisions and everything else. And then they are putting together this technical committee. Now, just for argument's sake, let's assume they come up with a report. Where will they take it? Okay.
Because the only report that can be handed over to the president is one that is initiated by the president through the Inquiries Act?
Yes, there's always a framework for that. Yeah. Okay. So we have separation of powers. Now, when it comes to legislation, that is the responsibility of the executive branch of government. ECZ has no power to initiate any legislation. Okay. So that is already dabbing into things well beyond the remit of your authority. And there is another point also which we shouldn't forget, which is that, first of all commissions, this is very important. This is addressed in Article 216, which says, all commissions shall be subject only to this Constitution and the law, shall be independent and not be subject to the control of any person or an authority in the performance of its function. 3, act with dignity, professionalism, propriety, and integrity. D, be non-partisan. And E, be impartial in the exercise of its authority. Now, the moment the role of ECZ is to conduct election, that is all. And what it can do some sensitization and everything else. But it has absolutely no authority to begin to talk about the Constitution and the rest. Now, if there is a problem, because they can't even say there is a problem, there is no problem. Okay? These are because this issue, ECZ ought to stay out of it.
Okay, can I ask?
Yes.
I'm just looking at that, the ECZ Act.
Yes.
Article 4 of the ECZ Act, Section 2H.
Yes.
Provide information and advice on electoral matters to state organs. Would that not be, would this not allow them to create some form of a committee that can dissect and then...
No, that is well beyond the remit of the authority. Okay.
So that wouldn't be providing information.
Yeah. But the point is that you have put the technical committee. Now, remember, when you're a public body, when you decide to do something, there must be a law that empowers you to do that. You can't just wake up one day and begin to invite members of the authority.
Just the second point then. Conduct and promote research into electoral matters. Would that not?
No, it wouldn't. Yeah, this is something they can do on their own. That they can do their own research, yes, for their own internal use. Yeah, but it cannot extend to that level.
Okay.
Yeah. Now, there is another point which is also important why I have an issue with whatever discourse that is taking part. You know, there is something that public officers are always required to do. That is to take oath. Okay? The president, when he took office, he took oath. Mrs. Alumis, when she took the commissioners, when they took up their offices as commissioners, they took oath. And I, as a lawyer, I took oath to defend the Constitution. Okay? Now, let me just read the actual oath of the president. Now, the oath of the president says, just read it in part. Do swear that I'll faithfully and diligently discharge my duties and perform my function in this high office, that I will uphold and maintain the Constitution. That's the oath he took. Nowhere does he say, I will only uphold and defend the provisions that I agree with. It is the entire Constitution. Okay? So you don't take oath, and then after you have taken oath, you now start saying, oh, by the way, that Constitution that I took oath to uphold actually has lacunas. You can't say that. Okay? You take the Constitution as it is, not as what you think it ought to be. And the same oath, now in the case of, for example, commissioners, they take what is known as the oath of office. And the oath of office clearly states that I will preserve, protect, and defend the Constitution as by law established. Those are the oaths that these public officers have taken. Now, how do you then, after taking those oaths, you turn around to say there's a problem with the Constitution? Your job is to enforce the Constitution and respect the Constitution as it is. And that is why it is even wrong for ECZ to begin to say, oh, we have a problem with Article 52 6. If you have a problem, go to the Constitutional Court. Okay, so these are some of the problems that I was saying. It is important for people to take time and study the Constitution, because it is the manual on how this country has to be run. Now, you don't have to agree. It's not like you have a choice. It is what it says. Okay, you have your view, I have my view. At the end of the day, our respective views are inconsequential. We go by the Constitution as it stands, and not as we think it ought to be. Because when we allow, okay, you have your different view, I have my different view, so which view is going to prevail? And that is why the Constitution provides in Article 1.4 to say you cannot question the legality of this Constitution. You assume, you proceed on the assumption that everything in the Constitution is correct. That is the premise on which the Constitution is founded.
The only time you can make the assumption.
Pardon?
It's the only time you can make the assumption.
Oh, it's there in Article 1.4. Yes.
Yeah. Listen, I want to thank you for coming on the program today. I know that I think maybe we've helped a little in terms of the debate that's going on in the country. I know that it won't end. There will be people who will still have a certain belief. But I think maybe the important thing is if you do have a question, go to court.
Yes.
So that the court can.
Oh, yes. Go to court.
Yeah, go to court.
Not engaging in lawlessness. We have a specialized, in fact, Article 1.5 clearly says any matter to do with the Constitution, go to court. Yes. So if you have a problem with the interpretation, go to court. Go and ask if you believe there is a lacuna. Go and ask the Constitutional Court. They will tell you whether there is a lacuna or not. Okay. But you can't say, well, because I'm president, I believe there's a lacuna, therefore we have to amend the Constitution. No. Okay. And the President Lungu set that precedent. He had doubts as to whether he would qualify to stand in 2021 or not. He didn't just take up a platform to say, guys, I'm standing in 2021, I qualify with respect of whatever you said. No, they took the matter to court, and the court adjudicated on that. There is another point which I'd like to make. One of your callers made a point. Before I come to that, the last caller mentioned about Article 2.
Yes.
Article 2, remind me before so that I can continue with my thought. We don't have to believe that we're dealing with a hopeless situation. Sooner, I think 2016, soon after the parliament was dissolved, we said the ministers continued in office. We said, no, you can't continue. Okay? What did we do? We didn't fight with them. We went to court. We said, court, these people have continued in office illegally, and we want them to pay back all the money that they received in the 3 months. And the court agreed. They said, yes, your mandate ended when parliament was dissolved, and therefore whatever money you got, they paid back. I'm sure you remember that case. Yes, we've indicated we articulated the Constitution, and what happened in 2021? All ministers left their offices soon after the dissolution of the National Assembly. So they learned. So we had a problem whereby one person took the view to say, no, we have to continue until after the election. And we took the view, said, no, you can't continue the moment the National Assembly is dissolved. Your mandate is over. So we had two competing views. We didn't go for the amendment of the Constitution. We didn't say there is a lacuna. We went to court, and the court interpreted and determined that these people were illegally in the office, and they paid back the money. On Article 2, it is important. It is my plea to Zambians. You need to defend the Constitution. The Constitution cannot defend itself. And that is why in Article 2, there is a duty on every Zambian to defend the Constitution. Okay? Because it is who we are. It defines us. Okay? So no president should be allowed to amend the Constitution at will. Okay? And if there has to be any amendment of the Constitution, there has to be consensus. There has to be evidence to prove that the Constitution has failed. But I'd like to believe that if we respected the Constitution, there is no way we can arrive at a conclusion that the Constitution has failed, because the Constitutional Court will tell us what the correct position of the law is.
State Counsel, thank you very much for coming on the program today. I had one last question I wanted to